Good evening, everyone. My name is Izzy, and I would like to welcome you all to the Harris Law Firm's webinar series, Wiser Together. Tonight's webinar, we're going to be discussing IRS frustrations, legal strategies for navigating tax liens and penalties, and we are incredibly grateful that you are all able to attend. As a member of the Colorado community for over 25 years, the Harris Law Firm has always tried to give back. This and future webinars are a free service that we provide to our community. Now, I would like to introduce our presenter today, Steve Cizik. Steve is an experienced Colorado attorney who serves of counsel to the Harris Law Firm's tax division, where he helms our tax law practice and assists our clients and attorneys in a range of tax law matters. Tax related matters. A graduate of Syracuse University College of Law and UC Boulder, Steve is an accomplished trial lawyer and one of the region's most respected tax attorneys. Over the course of his nearly 20 years in practice, he's cultivated a reputation for his extensive knowledge, negotiation skills, and ability to uncover precise and practical solutions for clients. His track record includes, in addition to years of corporate litigation experience and extensive tax law representation, successfully representing hundreds of businesses and individuals in complex tax cases, litigating high stakes matters on behalf of Fortune 100 clients against large Denver and national firms, and saving his clients millions of dollars in tax liabilities. Without further ado, Steve, I will turn it over to you.
Thank you, Izzy. I have a lot of things that you have to say, so it's okay that
All of a
you
sudden, my
stumbled
tongue
on
got
some of
very,
that.
very twisted there.
It's taxes, man. It does it to you. I appreciate you. This webinar is, timely. It is being recorded, 7 days before, 6 days before tax filing on April 15th. Obviously, if you're viewing this at a later time, still relevant information. But we are getting, questions a lot right now because of tax season about tax liens and also penalties as people are filing returns and noticing that there are balances, and then there's some concerns when they're not, they're not actually being able to pay them in full. So we're going to go through some of those, talk about, some of the things we need to be worried about. So talk about some of the things we don't need to be worried about. And then I'm going to give you some practical advice, with respect to sort of the pie in the sky stuff you hear on the radio as far as removal of penalties and interest. And I like to call it lollipops and hummingbirds. Other people call it rainbows and unicorns, whatever you want to call it. But the end of the day, you really want to approach any sort of IRS strategy intelligently and not really, go chase the dragon, so to speak, or throw good money after bad. So we'll go through those options as well. First thing we'll go through here is our agenda. I'm going to talk about what a tax lien is and what it is not. How to deal with a tax lien. Typically people, for whatever reason, tax liens are just an enigma for people and they're not really sure about how they operate. It's actually not that difficult, and we'll go through that and how we can address them. Then we get into tax penalties, the types of penalties, and certain penalties we can remove, certain penalties we can't, and then there's strategies for doing that. And those strategies for reducing and removing those penalties are at times actually pretty broad. So we want to make sure that we're approaching them, correctly, and like I said, not throwing good money after bad when we do so. And then we'll finish up with some final tips. I always have, they call them Steve-isms, but I have sayings that I have with respect to dealing with various different IRS issues. I use the terms brain damage and intellectual tap dancing a lot. But if you've worked with me before, you would get used to that, and that's just part of my ethos. So we'll talk about some of those tips and some of those takeaways on the back end. All right, so what is a tax lien? Um, you get a letter in the mail from the IRS, and it says, you got 30 days to pay $300,000, or we're gonna file a tax. Right now, we're gonna pursue, collections actions. Right. I have had family members call me, said, I got a notice, our payment got misapplied. Now they're gonna lien my home. How can we prevent that? I can't run down to the IRS office with a $30,000 check right now. I just don't have it. They're gonna put a lien on me, So how do I prevent that? That's the end of the world. What is the problem? There is a misconception about what a tax lien is. A tax lien is essentially just the IRS verifying that you owe taxes with the proper local districts. This is similar to if you take a house loan. The mortgage company files, their paperwork with the state and the county to prove that you owe them money, so that you don't, skip out on your obligation to them. Same if you have a car loan. If you have a note with somebody, they file what's called a UCC1. This is very similar to what the IRS is doing. They are just filing with the county to say, hey, look, this person owes us some money. There's no enforcement, action associated with it, right? So, oh my gosh, they're gonna lien me. Okay. I also have a mortgage. I also, I owe this, company $200,000 for a business loan. They also technically have an encumbrance against you, and a lien just falls in line with those. All right. So, when we worry about a lien a lot, specifically with businesses and things of that nature, it's not, a stop sign, and it's certainly not a death knell for your company. It's just something that is verifying for the IRS that you actually owe some money to them. Um, this creates a secured debt, just like a mortgage, right? Like as mentioned. So we do hear about in my contracts law class, and got out at Syracuse. I'll never forget, my old professor running up and down the classroom stairs saying, "We're racing to the courthouse with our paperwork. We're racing to the courthouse with our paperwork." And it's literally that. It's first in time, first in right. So if a mortgage company files, their paperwork with the county, and then there's a tax lien, the mortgage company actually has priority in front of that tax lien, right? So it's whoever got there first and filed their paperwork, that's a secured debt, and then the other debts fall in behind that, whether that's a secured loan, whether that's some sort of student loan or something like that. It's going to go in behind whoever was in front, and the IRS has to follow those same rules, right? So if the IRS comes in and it files a lien on your house, but you actually owe more than is that it's actually worth, then that lien actually has no value, right? It's a tax lien. It's saying that there's owed money, but the mortgage company is going to get paid first, and then the IRS will still be holding the bag, so to speak, with respect to those taxes. So one thing that a lien will do, obviously, it will encumber any equity in the home. So if you're looking to get, lending, or if you're looking to sell the house, that lien is something that's going to have to be addressed in connection with it. Impact and implications of a tax lien. So liens can be filed, at any time after a notice has been issued. So the IRS has the requirement to let the taxpayer know that they owe the taxes, right? So hey, typically it's a series of about three notices, where the IRS will, send you hey, you owe us some money, go ahead and pay it. Would love for you to go online and do that immediately. Then you'll get another one that says, hey, you didn't pay that. You didn't pay that money. We might actually take some action. And then you'll get a third one, which is, the scary one that comes in a certified, note, green envelope that says, hey, we're gonna, levy your assets and place liens on your accounts if you don't pay us within 30 days. Once that notice process has gone through, the IRS at any point can file a lien. Sometimes they don't. Sometimes you don't owe enough, right? And they don't get around to doing it. Usually it's about 10,000 or more. But I've seen liens filed on literally $5. It just is, there's no rhyme or reason to it. I actually have a client who owes millions of dollars and no tax liens have been filed. We don't know why, but we're not calling the IRS to ask because then they will, right? So it's sort of you know, random process out there, and there's no rhyme or reason to it. But the IRS can at any point file a lien unless there is some action that's been taken to prevent that lien from posting to the system. IRS liens attached to social security numbers and EINs, not specific properties. All right, so this is something that title companies and individuals have a hard time understanding. It is not a tax lien against, 9502 Gray Street, right? It is a tax lien against Steve Cizik. All right. So, and my social security number. So anything that, if I have a tax lien that's held against me, or my spouse, basically anything that me or my spouse have my name associated with on title is going to carry that tax lien, right? So they're going to lien my property. No, they're going to file a lien against you. And if you own a property, then that lien is going to attach to it. And usually it's going to be relevant with respect to tangible pieces of property that have title. So cars, business equipment, homes, commercial properties, large forklifts, things of that nature, where there is a business that has that asset. The IRS does not have the time or inclination to go out and inventory, people's assets. They say, look, anything that this business owns that is a tangible asset, if they are to sell it, then we will get the equity before they can take that money, behind any other priority lender, right? Um, and that's just one thing that I think a lot of times I get calls, panicked calls, say, oh, they've liened to my property. Well, no, they've put a lien on you. All your property now is encumbered. So we need to look at what that applies to, right? And there is a provision associated with the lien that says that it attaches to intangible property as well. Very hard for the IRS to enforce that. So how do you value the blue sky of your business, right? So, and a lot of times when we're dealing with tax liens, we're really just trying to focus on the tangible assets. But, if we're selling a business and there's a valuation that does include goodwill or something of that nature, the IRS could sweep in and say, well, our lien covers that as well. And that's when you need a tax attorney, because we like to argue that that's not the case. So this just ensures the equity in the property if it's ever sold, and there is equity beyond priority lien holders, and debt holders, that it would go to the IRS before the funds go to either the selling party or to non-secured, non-priority debts. Usually non-secured, non-priority debts are like credit cards and unsecured loans from family members and things of that nature. Shareholder loans, things that have not been filed with the court, I'm sorry, with the county and the state, that would perfect their interest, right? So the IRS would say, you've got a house worth $1 million. You've got 200,000 in equity. The mortgage company is owed, 100,000 of that. That remaining 100,000 is going to have to be paid to us before we are going to actually release the lien on that particular property. In that particular instance. All right. And that can be business property, that can be equipment, that can be, sometimes it's accounts receivable, things of that nature that factoring companies like to, go ahead and attach to. And, business operational loan sharks like to, you know, get liens removed all the time because they don't want to have the IRS coming in and, putting their encumbrances on accounts receivable and things like that. So when can a lien actually create some issues? Like I said earlier at the top, liens are not this impediment to business operations typically. But if you're trying to secure an equity loan, the lender is going to want to have that lien paid off before they refinance, because they don't want to be in second position to the IRS if they refinance. If you're trying to sell a piece of equipment, obviously the lien is going to come into play as to whether there's any equity that needs to go to the IRS before that that piece of equipment can be transferred with clean title. Sometimes this comes into play with large assets of businesses. That backhoe that I'm talking about, or that excavator, the IRS is going to want to ensure that there's clean title passed between the buyer and the seller. And so it would be the DMV who's going to register that vehicle, and we would have to provide that release to the DMV to make sure that there's no encumbrance with respect to it. Once again, it's a speed bump, not a stop sign. Certainly liens are not ideal, but they do not prevent the selling of properties. They do not, prevent, liquidation of assets. They just make it so that the IRS is a party to that sale, so that they can make sure that their debts are paid. This is a new one, well, newish. Liens are notoriously inaccurate. IRS will file a lien on a balance, and that balance will go up by $20 because of an additional penalty, and they'll file another lien. So now, if you've got a underwriter looking at a title report and they're looking for encumbrances, they see two IRS tax liens. That's not double the amount owed, though that's just one lien and then an updated lien of the exact same amount. But if you're not sophisticated enough or you don't understand the process, you are now calling your client as a title reporter, an underwriter, or a broker, and you're saying, look, you've got $200,000 of tax liens. And, clients call me, well, how is the IRS just double the amount I owe? I've not done anything, that would require that. It's a double filing, right? So because of that, the credit reporting agencies have identified it and they've said we're not going to include tax liens on credit reports anymore. They're just notoriously inaccurate. It's causing all sorts of problems, and it's hardship for our people and our clients that we're reporting to. So they just don't even show up on there. They will show up on title reports, right? So if you're running a title report for for the sale of a house, or if you're trying to do some due diligence on the purchase of a business, it's always a good idea to go ahead and just run a title report on the business, and you can then identify any sort of encumbrance that has been filed by the IRS, or really any other party that has any lending interest against that particular entity, and that's what that would show up. Those are usually only done when you have the sale of a real property, or you're looking for some sort of lending. That's really the only time that a tax lien becomes um, an impediment, I would say, or at least a speed bump with respect to sale of an asset. Releases of liens can be secured, but they're limited, right? So this drives me crazy. I got literally today a client, reached out to me, uh, had like a Department of Labor lien with the state of Pennsylvania for $80, and it was preventing him from closing on this multi-million dollar business lending structure that he was working on. Now, this lien was known about. I think it'd been in place for 4 years. We didn't know about it because it was the DOL was super random and it was $80. But the title company did not run a report or find out about this until literally today, and they're closing tomorrow. All right. Releasing a lien, thankfully it was only $80 because I was like, pay it, and then they can release it. That's the easiest way to get a lien release. You just full pay it. And then the IRS or the state will issue you a lien release. They do have a time frame in which they, allow themselves to do that. But we can expedite it in situations like I had today. But a lot of times these things come up very late in the process, and the IRS and the state, they don't work very quickly. So you can release a lien through payment. You can also release a lien if you don't owe that much and you put yourself on what's called a fresh start installment agreement. So if you owe less than $25,000 to the IRS and you've got a tax lien, you can actually set up a payment arrangement that sets terms to full pay it within 60 months, and you're on an auto draw payment, and they will actually release that lien even though you still owe money to the IRS. Otherwise, you would have to, you'd have to appeal a lien to try to get it released, and we can talk about that a little bit here on the next slide. What a lien is not. This is a fun one for me. I explain this to people all the time, and I, talk them off the ledge, which is this time of year kind of part of my job, I feel like. Tax lien is not an active collections activity. They're not gonna step into your house and take it because they filed a tax lien, right? This is not a situation where, Happy Gilmore, they're taking grandma's house. That's called seizure. That's a completely separate process, and it doesn't happen as quickly as, one might think, right? At least if you're watching Happy Gilmore. She wasn't responding to notices for about 2 years if that happens, right? A lien can happen quickly. Seizure cannot happen quickly. There's a big process for that. So they're liening my house. Okay. Mortgage company also has encumbrance against your house. It is what it is. It won't result in, levy of your bank accounts, right? So a lien, once again, it's just tying up any asset or value in any sort of tangible asset, but it's not resulting in anybody going to your bank accounts and taking money. All right. If they're leading my bank accounts, no, they will levy your bank accounts. And a levy is something we need to be very worried about. If you do get a notice that says that you're about to be levied, you need to hire Steve Cizik or some other tax attorney to help you out with that, because that is a very serious issue. And you do not want to be trying to put gas in your business truck and calling me on a Thursday morning and saying your debit card didn't work, which happened last week. Um, will not result in a garnishment of your wages. Once again, it's not a collection activity. So if you've got a lien, you're not going to have a notice to your HR department indicating that they're taking your money, right? So that's just not something that a lien does. Garnishment, once again, this is a very effective collections action, and you do need to, obviously engage with an attorney if this happens. But it's not a lien, right? A lien is just that first encumbrance that we're dealing with. A tax lien is no longer a public shaming device. It used to be. You hear about back in the 50s, right, when they would publish tax liens in the local paper. It was a shaming device, right? It was a legal tool that the county and state and sometimes the IRS would use in order to get people to pay because they didn't want the neighbors to know that they owed taxes. That's not happening anymore. People ask me if that's the case. That doesn't happen. Is it illegal for the IRS to publish, information about liens in the paper? I don't think so. But they're just not doing that anymore, mostly because it's just inefficient. And once again, their information is a lot of times inaccurate. They only show up on specific title searches, as I discussed. They're notoriously inaccurate. And employers are never notified. I had a specific case where a client of mine was a real estate agent, and she was worried that a tax lien would result in the end of her business because everyone would find out that she owed taxes. Well, it's not going to show up on your credit report. And there's no publication, and nobody's going to call Remax and tell them that you have a tax lien, right? It's not something that the IRS does. They file with the county, they confirm the debt owed, and that is that, right? So concerns over implications of a tax lien, other than sort of the limitations on sale of property and lending and things that we talked about, are not well based in fact, right? So it's a fear tactic, and it's just something that we I guess have been ingrained with as far as, IRS tax lien is the big scary thing. It's just not. The only time that it does become an issue is if you are a government employee. Tax liens actually can affect, sort of certain classifications as far as DoD clearance, and classified clearance and things of that nature. If that is the case, we can actually appeal a tax lien and say this is going to actually affect the ability of this person to, make a living, and we can have the lien removed or, subordinated in that particular instance. It's rare, but does actually occur. All right, so navigating these liens. So we've got one. We've found out it's not the boogeyman that everybody thought it was, but we want to get rid of it, right? So as I've indicated, it's a speed bump, not a stop sign. We can get liens released by those two easy parts. We can set up a fresh start payment arrangement if you owe less than 25. We can pay it all and get that thing released. You can literally make an appointment and go down to an IRS office with a check, and they will hand you a release if you have the money on hand and certified check. So we've used that before, when we're dealing with closing of properties and loans and things like that. Um, it's not as easy as it used to be. Since COVID, it's very hard to actually make an appointment anymore with anybody at the IRS. And everybody's aware of the political climate right now. There's not that many people working at the IRS right now, as there used to be. So try to think ahead if you're going to full pay a lien. You can also just pay the balance online, and we can secure a lien release by calling what's called the lien unit. So that's another option as well, and I'll fax that to you. A certificate of discharge. This is uh, the I guess the process that I mostly use when someone has equity in a property that is being sold or refinanced that's not going to full pay the lien, right? So there is a misunderstanding that you have to full pay a lien in order to sell a property. Like, well, I can't sell it; it's got a lien on it. Well, no, that is actually not true. You can sell it as long as whatever equity that you have in that property goes to the IRS. The IRS, it's a process, and you have to hire, counsel to assist you with this. But you provide the HUD, you provide an appraisal, you provide all of the relevant information on the closing documentation, the contract, to make sure that it's an arm's length transaction, and you're not underselling your property to try to get out of some tax debt. But as long as it is a legitimate transaction, an IRS agent will negotiate with your representative to determine how much money they feel they're owed from that sale. And what we try to do is include all the sales costs, all the improvement costs, legal fees, everything in that sale, so that the IRS is only getting what necessarily they are entitled to, right? And so that all the expenses that you're incurring are going to be covered by the sale, and then the remaining check will be then sent to the IRS. They actually send what's called a 90-day letter, and they'll say, look, as long as we get X amount of dollars at the closing of this property, we will release the lien. I send that to title and underwriting. They've got an official document from the IRS indicating that they will release the lien, and closing can proceed. I usually have to hold the title company's hand a little bit when it comes to issuing the check to the IRS because a lot of times they just send it to the Treasury and they don't actually allocate where the funds should go. But at the end of the day, as long as the closing occurred and the IRS got its funding, usually that's a good situation. The lien still exists, but it doesn't exist with respect to that particular property. It will discharge the lien in connection with that property. The lien against the person will still remain until it's either paid or one of those other vehicles that we talked about is taken care of. Certificate of subordination. This one's more difficult, right? So this is the one you kind of see on the YouTube videos where people are kind of touting that they can subordinate liens and we can still get you, lending because the IRS will put itself in second position to a priority lender. That's kind of what's going on here is that instead of giving a check over to the IRS, what you're negotiating for is that the IRS will put itself behind a another lender. And so then the lender can say, well, if there's a collateral asset, I would be the one that would have first priority to collect on that asset if this loan defaults. And the IRS would then be behind me. And in theory, that gives the lender some solace that they actually have, something to pursue in the event that the loan defaults. The problem with this is not that the IRS is disinclined to accept subordinations. Since 2009, I have had two accepted because of the banking crisis, right? So there are serious limitations with respect to whether you can find a lender who is willing to play ball with a certificate of subordination. IRS loves them. They would love to go ahead and put themselves in second position. Certainly, we take a portion of the lending funds. Say, look, we'll give you 50,000 if you allow for this $500,000 loan to be subordinated. IRS will take that money. They're not getting it any other way, right? So they're happy to sign off on that, and they still have their secured position. It's just behind some other asset, right? So, really, my I guess difficulty with subordinations has been getting a bank to sign off on it. A broker is happy to sign off on these things, right? Because they get their fees, whatever, they don't care. Once it gets to the underwriting phase, they typically get rejected, and then we got to, start all over, or basically it dies at that phase. So, something that is an option, but I've noticed, the realities of a subordination are a lot more difficult than, what one might promote, right? Title companies and underwriters have a hard time understanding tax liens and the process. That is not a referendum on them, but it is something that I've found that they are just not educated on. Um, and that's not a sweeping, referendum on them. But for the most part, I will receive emails from, underwriters saying, there's a tax lien, tell me when it's paid, right? And I will have already communicated with the broker and the bank and say, we're actually pursuing a certificate of discharge. We need to get, that process. I've given you the 90-day letter. It's not going to get paid. This is how we're going to move forward with this lien and have to explain that process to them. And inevitably they tell me the day of closing, there's a tax lien this needs to get paid. Like, no, I've been telling you for 3 weeks that we're going forward with a certificate of discharge, and this is how this is going to happen. So you may sense a little frustration in my voice because of that, and that's true because I feel like sometimes I'm banging my head against the wall trying to verify and communicate with people that are signing off on very significant lending instruments that these liens have been handled. They do have counsel. We have gone through the process, and this is going to be just fine. And let me show you why the IRS is going to be, not a problem for, signing off on this lending vehicle. Certificate of discharge and subordinations take anywhere between 30 and 45 days. And so if you are trying to sell a piece of property or equipment, you need to notify, the buyer that yes, there is an encumbrance, but I have a tax attorney, I'm working to have it resolved. We have to have an extended closing to make sure that you're going to get clear title to this particular entity. You don't have to say that there's a tax lien, right? Not at the sales process. But once they've signed the contract, we have to disclose there's a tax lien. And then I get on the phone a lot of times and I just explain this is not a problem. It's just going to take a little longer for me to make sure that you're going to get clean title. And I would say, at no point have I had a buyer walk away after I've had that discussion. They understand it and they're happy to wait the 15 extra days. They just want to make sure that they're getting clean title. And certainly that's my job to make sure that that's the case. That last bullet is really a function of being able to work with the various different personalities and dealing with this kind of institutional rush that is the underwriting process, right? Where we don't find out until the very end that there's a lien and that this has to be addressed. And so I get calls on the 11th hour so often that anymore it doesn't even frustrate me. It's just like, well, I'll be getting a call from the underwriter who hasn't even looked at the paperwork yet, 2 hours before closing, and I will then have to explain to them that we've already addressed all of these issues and it's not a problem, and all parties are, sort of moving forward, together towards getting the sale done. So, having counsel that's understand that that's going to be the case, and then also is anticipating it and can address it pragmatically, I think is very important if you find yourself in one of these situations. Tax lien appeals. Excuse me. Yeah. So tax liens can be appealed, but only in certain circumstances, right? So if the debt is no longer owed, I had a client who lost their house in the Superior fire, and they were actually trying to purchase another home, but the state of Colorado had a tax lien that was preventing it. And this is one of those things we found out, day of, kind of deal. That debt had been paid for 5 years. So, and so I had to, secure a power of attorney, and I had to, all hands on deck to get somebody at the state of Colorado to go into their files and confirm, yeah, no, this has been paid, and we just didn't get around to releasing it, right? And this goes back to the fact that most people don't even know, when a lien is filed because it doesn't show on your credit report. If you're not paying attention to the mail, which is, once again, a lot of people don't look at all their mail with IRS, especially if it's taxes. And they don't know that a lien is ever even in place, right? And then if they pay it, they assume it's been addressed, right? So it happens more often than I like to admit, where we're trying to move forward through some, very complex business lending, structure, and something pops out of left field from Alabama or something where it was, you know, uh, just didn't get removed, and then we have to go and then get the file the appeal and get the release and all the rest. So it's just paperwork, and sometimes it can be kind of eye rolling, but just be aware of that if you are going into some sort of lending situation. It's not a bad idea just to run a title report on yourself, right? You can just go to the county clerk and recorder and just put your name in there, and it'll show you, everything that's, been filed with your social security number on it. And the same is the true for an EIN for a business, right? So you can actually do some proactive, work on your own, to see if you do need to hire me to go deal with some, red herring that might throw a wrench in your lending, or your sale of assets and things like that. The debt is inequitable. A lot of times, I wouldn't say a lot of times, but there are times when there is a sale of an asset from one party to another with a lien and they don't get the discharge. If the buying party, didn't know or didn't understand that there was a tax lien associated with that particular asset, and now they've got this poisonous asset, I've been able to essentially tell the IRS and file appeals with the IRS and say, this is just inequitable. This person bought this thing. It's not debt that they owe. They need this. This combine to run on their farm, and now it's got $100,000 tax lien on it. This is just simply not fair. And the IRS, to their credit, will allow the release of that lien because it's not really that person's debt that they've acquired, right? But we do have to prove that that person knew that they or didn't really know that there was taxes when they acquired it, or they just didn't really understand that there was a lien, associated with when they paid the funds for it. Premature filing. This one is one that we use a lot strategically. Some people will file bankruptcy in order to get holds and in place for the IRS. If you file bankruptcy before the IRS files a lien, and then it subsequently files a lien, it actually has to remove the lien. They cannot take collection action while a business or a person is in bankruptcy. So in some cases, we've actually used that strategically to prevent liens, and buy time to get returns filed or get caught up on books and things like that, where a tax lien would prevent sale of assets and things like that, where a bankruptcy will help to allow for either a better resolution or to buy time to get back on track where we can then negotiate something more pragmatic with IRS. If you do have a fresh start agreement in place, and that can be actually under 50,000. So before we mentioned, you can get a tax lien released if you owe 25,000 or less. if they haven't filed the lien and you have, it's a moving target. But if you have below 50,000, I've done it up to 100,000, and you set an installment agreement on what's called an auto draft, they will actually in a mini kit in 50,000 and below, absolutely they will do it. Sometimes up to 100,000, they will say, look, as long as you don't default on this agreement, we're not going to file the lien. Right. And so you can actually prevent lien from being filed by pragmatically getting a agreement in place. And if they do file the lien at that point, we can actually, and it's 50,000 or less, we can actually appeal that and say you guys are in violation of the fresh start provisions. And then finally, a lot like bankruptcy and offer and compromise stops all collection action. I am not a huge fan of offer and compromises, and you can look at, you can watch some of my other webinars with respect to that, but they do have a strategic advantage in that they will stop all collection action, and that includes the filing of tax liens. So if they do file one and you're an offer, you can appeal that and get that released. So tax lien takeaways. And I know that was a lot, and I'm like drinking water here. The penalty stuff will be shorter, I promise. So liens are never good, but they're not the boogeyman, right? The IRS would like you to believe that they are. They're going to send you notices. There's a stigma in the world about tax liens. They are, once again, they are not this big bad thing where they're going to come lien my house and lien my kids, and I'm going to be destitute because the IRS filed a tax lien. That's just not the case. And I say this a lot, knowledge is power, and that's true in a lot of things. But when it comes to addressing tax liens, I think if you have a lack of knowledge and a lack of experience in dealing with it, it can be a scary, and very stressful thing. But for those of you that are watching this now or have watched my recording, hopefully after seeing this, you'll say, actually, I know something about what tax liens are now. If that lien shows up on my title search for either myself or for someone I'm working with, it's not something I'm going to, alarm bells are going to go off so much. It's going to be, hey, I know what that is, and I know that we can either deal with it or we can work around it. It's not going to be the end of our business relationship or the end of this particular deal that we're trying to work out. Understanding a tax lien, once you lose that fear factor, and I think this is kind of reiterating what I just said, you can strategize pragmatically and without sort of a gun to your head on how to either deal with the lien, file an appeal to get it released, or prevent one from being filed. So, overall, I think that knowing what a lien is, understanding what it isn't, is really going to put you in a good position when you do, identify a lien, in any situation, whether that's in a business context or whether that's your personal context or whether that's somebody threatening to file a lien against you. And this sort of basic financial structure actually applies across to, mortgage filings, UCC ones. Your HOA says they're going to put a lien on your house. Like, oh, darn, you got a lien on my house for $150. Like, okay. So it's not this scary thing that people have built these things up to be. They're very easily addressed as long as you're paying attention and you're not ignoring those issues. All right, a little bit shorter, and we got about 20 minutes, and I'll do it in 15 minutes so we can do some questions. IRS penalties, and types of penalties and options for removal. So common IRS penalties. So we've got, late filing penalties. It's pretty self-explanatory, like payment, failure to make estimated tax payments. So people who work for themselves don't usually understand this, but the U.S. taxation system is a pay-as-you-go system, right? So they got to keep the lights on throughout the year, not just at the end of the year when you file your taxes. And so if you are getting a W-2 and a wage, obviously there's money coming out of your paycheck every 2 weeks, and that's going to the government, and they're spending that throughout the year to keep the B-2s flying. So if you're a 1099 worker, a contract worker, the IRS expects you to follow suit, right? So they want you to make estimated tax deposits, actually make payments of your taxes or anticipated taxes every quarter. If you fail to do that, you can actually be penalized for that, and it can actually be kind of significant. So you really want to track that. Civil penalties, these are interesting. If a business, fails to file W-2s or their 941s, which are their withholding returns, don't line up with the numbers on their W-2s, there can be very significant civil penalties. They're called continuing annual wage reporting penalties. And there's also FUTA penalties for unemployment issues that if you don't pay your unemployment taxes to the state, the IRS finds out, and then they actually try to collect for for unemployment purposes, and those can be significant as well. So those are for businesses, and we deal with those actually a lot, and they're very significant, but they're actually fairly easy to address if you're properly represented. If you're just trying to send mail to the car unit, good luck. You'll hear from them in a decade. So we have some ways to actually address that. And the typical civil penalty on a car assessment is about $90,000. And so we definitely advise if you do get some civil penalty assessments for your business, that you engage with representation who knows what they're doing to get that addressed and removed. And then there's the interest component. You'll hear this a lot on commercials. We're going to get rid of your penalties and your interest. That is not true. It is a lie. It is a lie. The IRS does not view itself as a free bank. They are going to charge you interest for anything that you owe. Can we reduce interest? Yes. If the penalty is $10,000 and you owe $110,000, the penalty is accruing on $110,000. If we remove the $10,000, now the interest is accruing on $100,000, right? And so then that will adjust that interest component down systemically. So technically we are reducing and removing penalties, but we are not actually trying to get the interest component removed. We are reducing penalties, and then the interest will reduce along with that because the penalty component carried an interest factor, if that makes sense. All right, so this interest is crazy. I don't want to pay it. Well, the IRS, once again, they're the worst bank in the world, 22% effective interest rate. If you can pay your principal off, I always advise it. Trying to get the interest removed is folly unless there's some sort of settlement or if there's an incorrect assessment or something of that nature. And then there's accuracy and reporting. These are kind of like the audit penalties. So if you file a return, you get audited, and you have to sign that you underpaid, they will penalize you, and those are significant. There's tax fraud penalties. Those are never getting abated. There's failure to report. That's 1099s, things of that nature. We can actually do a pretty good job of proving that the failure to report was not intentional, and we can actually remove those. Federal tax deposit penalties. This is when you claim that you're going to go ahead and pay withholding taxes for your employees and you do not. That can actually become very serious, and we end up with what's called civil penalty or trust fund assessment, where the government can actually pierce the corporate veil and they will pursue the officers of the entity if that entity did not pay its employees withholding taxes. The reason why that one's serious is because the IRS deems it theft and fraud. If you give your employee a paycheck and you say, you made $100, but I'm going to give you 80 because 20 of that's going to the government, and then you keep that 20, the IRS does not hold that against the innocent employee. They never got paid, right? They will pursue that against the officers of the entity, and it can actually become very serious. So if you ever find yourself with trust fund or civil penalty, issues with a revenue agent, a revenue officer, certainly engage with counsel to assist with that. You do not want to handle that one on your own. This is a long slide, and I will just let this one sit. If you are recording this, you can take a look, but it does kind of go through the levels of the penalties. There's percentages up to max, but civil fraud, it goes up to almost 100%. Trust fund recovery obviously is 100%. And these things can pyramid very quickly, specifically the withholding and the federal tax deposit penalty ones for businesses. So if you have a payroll company that's not paying attention and you turn around and 3 quarters later you could owe $1 million in payroll taxes, you didn't even know it, right? So it can grow very quickly, specifically if you're in a heavily staffed sort of industry like staffing companies and things like that. We see very significant withholding penalties, and then that results in that personal assessment, those trust fund penalties as well. And we want to make sure that we're aware of those and we're staying on top of those. The goals for penalties, according to the IRS, are to encourage voluntary compliance, right? So they want the pain to be enough that you won't delay in paying your penalty your taxes or do it incorrectly. They want to educate taxpayers. That's actually in the code. They want to educate you by penalizing you so that you will learn to not do that again. It's gaslighting at its best. Um, what not to do when we're trying to deal with penalties. Don't argue with the IRS that it's just not fair. They don't care. They have codes. You saw all the codes. They're just going to go by their percentages, right? And if you didn't pay it, and if you at any point had the ability to pay it, and you didn't have, a legitimate excuse as to why not, don't say, well, this is not fair because this is just too much. And it's, how am I ever going to pay you guys back if you keep penalizing me? That is a losing argument literally every time you make it, right? So just don't. It is what it is. The person on the other end is not going to respond to it. And yes, it is not fair. I get it. Everyone gets it, right? It's the IRS. They're a collections agency. They're not in the business of, forgiving debt and things of that nature, right? So, trying to, stamp your hand and say this isn't fair is just simply not going to work. Don't give up. Say, I'm not paying this. I'm moving to Mexico. There's no way I can pay this back. We can always address balances. A lot of times we have resolutions that, don't even touch penalties after, an agreement is in place. So if you're looking at a large debt and you're seeing that number is going up $20,000 a month because of interest and penalties, and you find that, there's no way I'm ever going to get out of this. Yes, there are ways you can get out of this. The IRS can only collect on any debt for 10 years, right? So you're not going to be, unless it's like a fraud penalty or something, but you're not going to be, in debtor's prison for your life. And a lot of times, what I try to have my clients focus on is the resolution of the debt, not necessarily the balance, right? Because a lot of times the full balance is never going to get paid based upon what we've strategized for them. We've got, and this is one that is actually fairly important. You do have, sort of unethical firms that'll say we can get you pennies on the dollar, we can get all your penalties removed, and a lot of times it's snake oil. And what I advise is yes, take a crack at getting your penalties removed or abated or reduced. If it doesn't work the first time, it's probably not going to work a second, a third, or a fourth time, right? So every time that you're going back to the IRS to try to get these things reduced, you're spending money for counsel and for the filings and for the brain damage. Don't throw good money after bad, right? If it's not going to work, if your reason for not paying your taxes is you just didn't get around to doing it, don't spend $5,000 to file an appeal and say, well, I just didn't get around to doing it, but I'm a good guy. Like that's not a good argument. Why spend that $5,000 on a flyer when you can apply that, towards your debt or go invest it or whatever so that you can better put yourself in a better financial position. So don't chase the dragon and don't go after things that we can't necessarily get. So what you can do, you can file what's called an 843 first time abatement request. This is the most important thing I'm going to say on this webinar. 843 first time abatement request. If you're an individual or a business and you have 3 years of prior compliance and you have a penalty, whether that's late filing, late payment, sometimes there's audit penalties, file this form. You will get your penalties and your interest abated for one period. Everybody gets one. All right. So always look at this. If you've got 5 years of liabilities, look at your very first period that you owed and see if you qualify for that 843 request. You can actually call the IRS and say, hey, do I qualify for a first time abatement? They will run a calculator and say, yes, you do. I'm going to send you an $8,000 check. It happens. Literally happened to my brother. So he's gonna hate that I said that. But I got him that reduction just by knowing the law. So, that is the most important thing as far as abatement, and it's the easiest one that you can do on your own without counsel if you know how to file the form. It's online. You can file initial requests for abatement if you're in audit. So if you're in an audit and there's penalties proposed, we can actually approach the auditor and say, hey, there's reasonable cause here. Will you remove the penalties? We'll pay the rest. Sure. That's a really good way to go about it because that doesn't go through any appeals processes. The audit agents actually can grant that outright. And we always try to get penalties removed in the audit phase before it gets to a collections phase because it's much more difficult at that level. Reasonable cause abatement request. This is kind of like the bread and butter of penalties, right? So you can actually prove to the IRS that these penalties are not justified, and you have to draft it. And obviously, it's better if an attorney argues it. But some of the bullets are death, serious illness, unavoidable absence. That can be for yourself or a family member during the period in question. Natural disasters, obviously. Inability to obtain records. So if there was like a fire or something that burned your records, or CPA, took off to Mexico and took all your stuff and you couldn't file on time, these are things that we can actually tangibly prove, and certainly the IRS is going to entertain. Mistake was made despite ordinary business care prudence. This one is actually a successful argument a lot of times for contractors. When it's like, hey, I had a contract. I was acting as an ordinary prudent business person, but this guy breached the contract and I didn't get paid and I had no money. And if we can prove that, it's like, okay, well, that's not your fault. You filed, you weren't able to pay. We're not going to penalize you for that. You were acting, professionally. You didn't do anything intentionally. And so we can put together those facts. But, in any case, we have to prove it, right? So, I think it's A Few Good Men. He's like, I think you forgot the part of law where, we have to actually prove the law. So we can't just arm wave and say, hey, this is what happened. We have to actually document. A lot of times we're showing the books, we're showing bank statements, we have emails, things of that nature. So we're building our case. That's not just, Steve Cizik with his really good, writing technique. It is, this is what happened, and these are the various levels that occurred during this particular time. My father had cancer. When I was supposed to be filing, I couldn't get around to it for, 5 months later. And, if as long as we can prove that, we can remove those penalties. The IRS, they're not heartless, but they are bean counters, right? So we have to set the table for them. And then erroneous advice from a tax professional, the IRS. If the IRS gives you something in writing that tells you to do one thing and you do it and they penalize you for it, that's like the easiest abatement request I'll ever file. It's so rare, but it does happen. So keep everything they send you. If a CPA is giving you poor advice and you've got that in writing from them, a lot of times we can utilize that, try to reduce penalties in that case. The IRS does prefer that you pursue the CPA because they've got errors and omissions, insurance. But let's say you try to pursue them and you're unsuccessful, the IRS will then take that into consideration and they'll look at that advice that was given. Ignorance is a defense when it comes to IRS. So we try to, no, it's not they don't expect everyone to know what's going on with the code. It's constantly changing, and we can utilize that to our advantage. Final tips before I get to a couple questions. I'm sorry I've been a little long-winded here. So liens, they're not active collections. Those are speed bumps, not stop signs. Liens are not the boogeyman. And knowing more about liens, and I just advise every underwriter and title person out there, please just understand what a lien is. And if you don't, call counsel because we can make your lives so much easier and so much easier for your clients. Penalties, they come in all forms. They can accrue in pyramid. Understand your strategies, regardless of the penalties. Are we dealing with not full paying this debt anyway through my strategy to resolve this with the IRS? So why I'm even worried about penalties, because I'm never even going to touch not even the interest or the full, at the end of the collection statute, they may not even pay the full amount of the principal. So I'm not going to worry about penalties and don't let those bury you. Don't throw good money after bad. Don't go chasing the dragon, appealing to penalties when you don't have a good argument. And hopefully your counsel will actually be honest with you about that. And then certain penalties can be abated with the right facts, right? So you want to make sure that you go through the facts with your counsel, you're full, and you disclose everything to them so that they can make the best argument for you, and obviously put your best foot forward. So I made it in just under the time here, and I see that we have a few questions. Izzy, did you want me to just go through these,
I
directly now?
No problem. Yeah, I'll just read them to you.
Okay.
Okay. So here's the first one. How do we find IRS lien details, including amounts due on properties?
As I mentioned, IRS liens are filed with the county and the state. So if you have, if you know where the properties are, if you know whose name is attached to those properties, you can actually search. In most jurisdictions, you can search via property. Right? Go to just do a title search at the Secretary of State or the county and clerk recorder's office. A lot of times they're online. I know in Colorado it's all online. And they will just put every encumbrance that associated with that individual. And then if you look up by property, it'll show every encumbrance associated with that property. So all free information. You can just get it from the county clerk and recorder for wherever that property is.
Awesome. Okay. Here's the next one. Can the IRS file a tax lien if the property is in a holding company or LLC that has charging order protections in the operating agreement?
Absolutely. IRS does not care about operating agreements. Similar to how they don't care about divorce decrees, settlement agreements. They are not governed by third-party agreements. They can file against an entity if the entity owes, right? So, if the holding company or LLC owes money, then they can file against that EIN. Now, if we had come to an interesting, let's say there's an individual who owns the property, but they've transferred it into the LLC. We could have a review of the IRS for a potential fraudulent transfer. But let's say, for example, John Doe owes $200,000 of taxes. He transferred property legally into his LLC. Now the property sits under its EIN. That $200,000 tax lien will apply to John Doe. It will not apply to the EIN. And so, in theory, that property is not encumbered. We do need to be careful with that. I would advise you have counsel on that to make sure that we don't have any fraudulent transfer issues because the IRS does not look fondly on hiding assets, if that makes sense.
Alrighty, and then this one, let's see here. My ex-husband and I owed 5 years of taxes. 4 years have been paid at this point, but the final year is the largest, more than 25,000. Will the 843 help me abate penalties for that year, or will they go back to the first and smallest year to figure that amount?
Yeah, unfortunately, I think you know the answer to that one because you identified it in the question. So that they're only going to go back to the very first year. It has to be 3 consecutive years of compliance, right? So sometimes if you had, let's say you owed 12, 13, 14, and then there was a period in between there and you owed 20, 21, 22, you could get 13 and 20. I would still say go ahead and file an 843, for that first year and at least get something back that you can apply towards the 25. But unfortunately, 843 is not going to assist, directly, with respect to the most recent period. It might be a period though that you would want to file a reasonable cause request because you could say that you've, acted in good faith, you've paid all the debt down, you could, cite any reasons that you owe for that last year, and maybe you can reduce it on that end.
Awesome. Well, thank you, Steve. That's the last question, and we are out of time, so it worked out perfect. Any final
Oh
words
man,
before we
one
sign
minute.
off? Yeah, any final words before we
Uh,
sign off?
yeah, so I just, wanted to just, go back to my original thought with respect to knowledge is power. When you're approaching the IRS or the state, if and you don't know, what you don't know, contact someone who does. Because the stress level of just having a 30-minute conversation with someone like me, will take you from, DEF CON, 1 back down to 5, and you can actually make decisions that are going to affect your life financially, with that peace of mind. And so, take advantage of the people that are around you and the resources that you have. And certainly, here at Harris, we're happy to provide those, and certainly look forward to working with you.
Absolutely. Thank you, Steve. And as Steve mentioned, are offering a free webinar for a thank you for attending our, excuse me, we're offering a free consultation as a thank you for attending our webinar this evening. Just give our offices a call and they will get you all set up to get some more of those questions answered. With that, we hope to see you at another Wiser Together webinar and have an excellent evening, everyone.